morning on Wednesday, January 28th. We are in the State Office Building at 75 Alcuni Street in Hilo, in conference rooms A, B, and C.
In the meeting, so I gotta go. Okay, great. I love that. Right, look.
This hearing today is the public hearing on proposed Hawaii administrative rules, specifically newly proposed Chapter 11-160 of the Hawaii Administrative Rules, titled Medical Use of Marijuana. The public notice of this hearing was published in the Honolulu Star-Advertiser, Hawaii Tribune-Herald, West Hawaii Today, Maui News, and Garden Island. With copies of the hearings notice are available in the back of the room. There are also a few copies back there somewhere of the proposed rules for those who wish to look through them. With me today is Peter Whitaker, who's the branch chief of the STD/AIDS prevention branch, and also is Scotty Ruiz, who's the medical marijuana program manager, who's come over to the health department to handle this program. The purpose of this hearing is to gather public testimony on the proposed regulations. There is also an opportunity, and I will give you the address. The address has been published already, but I'll have the address again to submit written testimony as well. The purpose of having the hearing is that this testimony will be considered by the branch in deciding whether to forward these proposed regulations to the legislature, to the governor's office, or to modify them before they were forwarded. And the testimony that's given today, as well as and on other islands, which is going to follow in the next week, as well as with the written testimony, will be considered in deciding what the final version of the regulations that is forwarded will look like. Peter Whitaker is going to do a description of the proposed rules and make any comments he wishes to make, so I'll give him before testimony is taken.
Good morning, everybody. You know, I was out here a few months ago, and it was a separate hearing, and it was over in the other building, and I can see why people are a little bit confused. I probably would have gone there myself today too. That hearing was about dispensaries, and I met a number of you at that hearing. This hearing, as Stephen has said, is specifically about the administrative rules for the laws that currently exist. This isn't a hearing that's related in any way to dispensaries or to legalization or decriminalization or rescheduling. And I know there's really a lot of energy around these topics all across the state and in Oahu too. And there's quite a number of bills that are being introduced this year in the legislature. Now, that process, those bills are to change the law. Okay, and that's separate from what we're looking at today. What we're looking at is laws that already exist, and the law was one that was passed 18 months ago, and that law was to move the medical marijuana program from the Department of Public Safety. And for those of you particularly on the Big Island, I think you're very familiar that since the year 2000, when medical marijuana became legal in Hawaii, that program has been administered by the Department of Public Safety. And it was through, I think, a lot of activism from people in Hilo and the Big Island and all across the strait that they thought that medical marijuana is a public health issue. It's not a criminal activity. It's not a law enforcement activity. So the legislature agreed with this approach, and in Act 177, they moved that program from public safety to the Department of Health. And I think, as many of you know, starting January the 1st, that program started with the Department of Health. Well, you know, we never had a medical marijuana program before. We didn't have the staff, we didn't have an office, we had to learn about it. And you know, in many states, when the Department of Health takes over that program, they take it over when the program is brand new. So they have 1 patient, then they have 2 patients, then they have 5 patients. When we took over the program starting January 1st, there were approximately 13,000 patients. So it was a big chunk to take on at one time. And Scotty Ruiz, who just started in May of this last year, has worked with myself and a few other people to try and get that program up and going. So these days, when you're interfacing or you're looking at the website or you're sending in applications, if you're a physician, if you're a patient, whoever you're interacting with the Department of Health is primarily with Scotty and myself and the program that we've got. Ultimately, we're supposed to have 4 staff. Currently, we have 2 staff. So our real focus at the moment is making sure that those cards get out to people that need renewals. What we do not want is people that are putting in their applications and there's such a delay that they're caught needing their card but they don't have it. So that's a little bit of background as to what's going on. Now, I'm sure some of you are wondering, why is the chief of the STD/AIDS prevention branch, why has he got anything to do with medical marijuana? Well, I think as all of us know, there's no real connection between medical marijuana and sexually transmitted diseases. And you know, there's a number of jokes that have been made about that, and I'm not going to tell any of them right now. But it was basically because we have a strong public health record. In HIV, we spend a lot of our time working with our stakeholders. We spend a lot of time listening to the people we're trying to serve. We work with law enforcement, we work with doctors, and we work with patients. And for those of you that are familiar with the history of HIV, you know how important that was in this country in shaping our response. And a lot of how this country dealt with HIV was about listening to people that had HIV, because those are the people that cared the most and knew the most. And that's very much a public health perspective on how programs are implemented. And what our plan is that for medical marijuana in the Department of Health, we're going to very much follow that approach. And part of what we're doing here today in this public hearing is listening to you, who are key stakeholders. There is no purpose in having a medical marijuana program unless you're serving the interests of the patients that receive a certification for medical marijuana. So I'm going to give you a brief description of the rules. As Stephen has said, there's copies back there. And today when you're giving your testimony, if you can be as specific as possible, that will really help us. You're welcome to say whatever you want relating to the rules, but the more specific you can be, the more useful it is for us, because we're going to try and figure out exactly what it is you're saying, what it is in the rules, do they need to be changed or not? Because what we're finding already is there are different people that have very, very different perspectives on exactly the same topic, and we may even find that among the group of people that are here. So let me see, so what we're looking at is a new set of administrative rules. Currently, the administrative rules that we are using in the Department of Health are the same rules that came from the Department of Public Safety, because until these new rules that we're talking about today come into effect, that means they're signed off and accepted by the governor, we're obliged to use the rules that previously exist. So by and large, what we're doing now in the program, if you're applying for your card, if you're a physician, you are coming under the current administrative rules. The only exception to that there are some changes in the law that happened that are not in the administrative rules of public safety, and we had to make some accommodation for those. One example of that is in the old law, you were allowed, I can't remember, was it 4 mature plants and 3 immature plants?
3 mature.
3 and 4, the other way around. And 18 months ago, that changed to 7 plants of any size.
And it changed this month.
That's right, starting with the law, it changed and coming into effect January the 1st. So we will, any changes that are like that, we will be following the law at this point. The proposed new chapter sets forth rules for medical marijuana program under the Department of Health. including a process for the department to approve debilitating medical conditions. Now, in the years that I've been learning about medical marijuana in Hawaii, one of the things I've heard most from patients and physicians is that we need to have a process for considering new debilitating conditions. As you know, the conditions that are acceptable for medical marijuana are the same conditions that were established when the law was established in the year 2000. Okay? In these rules, and I hope you really had a good look at that, there is a process that is in place that permits patients or physicians to petition the Department of Health and request that new conditions be added to the list of qualifying conditions. Personally, I think this is a very important part of the rules, and we look forward to hearing any comments you have on that in particular. It also talks about physician requirements to participate in the medical marijuana program, the registration of qualifying patients and primary caregivers, the monitoring and corrective actions, administrative procedures, and confidentiality of information. Those are the main sections that are in the administrative rules. And if you're looking at the rules, at the beginning, there's a subchapter with each of those topics. And the very first one is the section that goes through definitions. So it's really worth looking at the definition section, because all through the rest of the rules, when they're talking about, they're using some terminology. The terminology means according to the definitions that are in the beginning part of the rules. And that may not be your understanding of what the definition is. So it needs to be based on the definition that's at the start of the rules. Now, while there are similarities with the existing public safety administrative rules, we did not take the administrative rules from public safety and just tinker with them. We didn't think that that was a good starting place. So what we did is we collected information from the existing rules, we collected information from physicians, from patients, from activist groups, organizations that exist in Hawaii that were looking for a change in the rules. And we also went out and we met with people. We met with doctors, we met with physicians, we met with these activists, we met with law enforcement, because law enforcement is clearly a stakeholder in this process as well. And what we did is we incorporated the changes in the medical marijuana laws that were in the law from Acts 177 and 178. And those were the ones that were passed in 2013. And we created this new process for considering debilitating conditions. We added requirements to improve investigation and enforcement, and I know a number of you are interested in commenting on that section. We increased the operational flexibility for the administration of the program. And one of the things I would just draw your attention to is that will give us the possibility to receive electronic signatures and applications. The Public Safety Administrative Rules requires that there's an actual physical signature. And that's why physicians currently are submitting applications both online, but at the same time they have to sign papers and submit papers, and so do the patients. When these new administrative rules, when they are approved, this will permit electronic signatures, and the hope is that at that time all the application will be online and there will not be this duplication of online and hard copies submitted. And we believe that it better defines and clarifies the requirements. One of the things that we tried to do in these rules is we tried to use language that we believe normal people can understand. You don't have to be a lawyer to understand these rules. Now, we'll be glad to get your comments on that, but we really did try to simplify it, because our belief is these rules are for all of us. And if you can't understand the rules, if they're written in a way and using terms you can't understand, you don't really serve the purpose of the public. And we reorganized the chapters, you can see compared to the way that the public safety created the rules and we wrote them, that we tried to organize them in a sort of a step-by-step process that you could sort of imagine the process, you could understand the process that you would go through in understanding the program. I mentioned what this hearing is not about. After this hearing is over, if we still have time, I think we'd be happy to talk with any of you and hear your thoughts about dispensaries or legalization or other topics. But again, that is not the topic of this hearing. If you need copies of the rules,
Just for the benefit of I arrived late, could you tell me what the topic is so I'm not sitting here confused the whole time?
sure. The
Thank you.
topic is consideration of new Department of Health administrative rules
Oh, sure.
for the medical marijuana program, and there's copies at the back or they're available online. So
Oh,
it's,
this whole book, all right.
yeah. And the book is there so you can refer to sections, or if you didn't bring a
You got
copy,
it
you can
online
have a look at
posted
it.
somewhere too?
Yes.
Thank you.
Okay, now copies are also available online. So today you can testify in person, you can submit written testimony, or you can do both. We really appreciate it if you give it to us in writing too, but we are recording this, and so we will know what you've already testified in speaking terms. You can also testify up until the 6th of February. So after you leave today, if you want to give additional testimony or you didn't have a chance to testify today, you can still submit testimony. And if you go to the Department of Health website, and I hope you do go to the Department of Health website because that really does explain the program, but there's a section in there about the new administrative rules and where you can submit written testimony. I think that's the overview that I wanted to give you.
Okay, let me just say that the, let me just add that the, in case people need to leave before the hearing finishes, the address for submitting written testimony is in the notice of the public hearing. But for those who don't have it, it's the address is 4348 Wiley Avenue, Waialae Avenue, number 648, Honolulu, Hawaii 96816, or by email at medical marijuana, no dots, you have it in the back there too? Okay. Medical marijuana at doh.hawaii.gov. It's not only if you're not able to give the hearing, but if you're feeling too shy to testify at the hearing, or you think of things you'd rather say after the hearing, you also have the avenue of going ahead and submitting written testimony. And if you have submitted written testimony or are going to submit written testimony, there are quite a few people here today. If you could maybe hit the high points of your testimony, if there's a lot of detail to it, so that others have a chance to talk. There's a sign-up sheet that's been in the back. That's going to be brought up front in the right about now, so I can see how many people have said they wanted to testify. After everyone who's checked the boxes has testified, I'll ask if people have decided after hearing, after whatever they've heard, or if they didn't check the box, you're going to be able to testify anyway, but it's going to be after the other folks have gone. And we have it coming. And for those who didn't hear, I'm Stephen Jacobson. I'm the hearings officer of the Health Department. I am here as a moderator for the hearing. My input into these rules and any prospective changes into them is absolutely zero. So you don't need to be addressing comments to me. The comments need to go to the program folks.
I actually have a comment for you. We have some friends that are cancer patients. I'm doing radiation right now and plan to come to this meeting after the radiation. So there will be at least 1 or 2 testifiers that will come in late.
Oh, that's something. Thanks.
There would actually be quite a number of people coming later, I'm guessing too, so.
Okay. All right, well, we've got 10 definite yeses, 1 see how it goes, and 1 who knows. And we have till 10:30 or so, so if you could maybe,
12:30.
I'm sorry, 12, we started at 10:30. So we have about another hour and 40 minutes. If you can keep it in the 5, 6, 7 minute range, so we in anticipation that we have any other people. And if you've already testified once but have one thought that you didn't forgot, maybe, you know, you've got time, you can always add it at the end, or mail it in, mail it in. All right, the testimony is going to be given from that table there, so the sound equipment is going to be moved from here to there, and then, well, we go. So Scotty can do that. And I'm just going to go in the order that people signed in, so Brad Snow first, and then to be followed by Jim Berg, I think, maybe. Mr. Snow.
Thank you. Thank you, everybody. My objections to this is mostly about the availability of the grow site to the police. See, I have a unique situation in my experience with this, that they have been to my house 7 times, and it is harrowing. Now, why can't it be set up to where they can respect the property ownership? They shouldn't be able to come on the property just because they see marijuana. There are 13,000 patients in the state of Hawaii, and they all should have a right to their privacy. When you have a helicopter traveling 50 feet over the ground in front of your house, it's pretty frightening. And then you know he's got an automatic weapon up there, and you know 6 guys come out of a truck right in your front yard and come marching up your driveway. Now, the last time they came, I asked them to produce a warrant, and they left. But the first 7 times, it's just unacceptable. Now, the issue of this privacy thing and search and seizure has to be addressed better. It can't be left up to the police because they obviously are trained to do what they do. I don't have anything against their policies about going after the bad guy. But you have 7 marijuana plants in your backyard doesn't mean you need a SWAT team to show up. This is what's been happening. When the dispensaries come out in the next 2 years or whatever it is the timeline might be, there's going to be a whole new set of rules because you're going to be dealing with the public. Right now, this is a private operation between patients, caregivers, and doctors. And what you've done here is put the government in between me and my doctor. You've also put the government in between the patient's caregiver for the medical marijuana and the patient himself. You also make these rules difficult for people who are what? Suffering from debilitating conditions. So if they have a plant that's not marked right, does that mean they lose their medicine? That's ridiculous. Come on. Realistically, 7 plants is not too hard for a police officer to be able to count. I really don't believe that's the issue here.
It's a public
Excuse
meeting.
me, no photos of the patients.
It's
This
a
is
public
privacy.
meeting.
I don't mind, so you know.
Well, I'm sorry for the interruption. I don't want to be photographed, thank you.
I'm sorry. I'm really concerned about the privacy issues for the patient, the caregiver. The police have to have access to the database. When they don't have access to the database, they treat it as a crime scene. So that is critical. The cards are secondary to the database. If the card is misplaced, lost, it got dirty, whatever, and they show up, happen to be that day, it's within the time period to get a new card. You lose your medicine? These guys are trained to do their job. If it's not perfectly clear, they will continue to do what they've done to me for the last 4 years. I've been in this program for 6. But my present residents, I've been there 4. And I've been harassed continuously by them. And I want it perfectly clear in these new regs how they operate when they come to a medical marijuana patient's home to check their medicine. Thank you. That's enough for me. Thank you very much.
Thank you, Mr. Snow.
Well said.
Dr. Berg to be followed by Lee Smithmeyer.
Good morning. My name is Dr. James Berg. I recognize a lot of my patients here. I've been involved with the medical marijuana program for about 12 years now, and I have quite a few patients. My concern is in the definition of a bona fide relationship between a doctor and patient. First of all, I believe it is the duty of the State Board of Medical Examiners to define a proper relationship between a doctor and patient, and to define when a doctor is acting fraudulently in his practice. And it shouldn't be left up to the Department of Health to determine how a doctor practices medicine. That's why we have the State Board of Examiners, and Chapter 453.1 establishes the guidelines for a physician with regards to pain medicine, and 453.8 very specifically defines the reasons for revocation, limitation, suspension, or denial of his license. So I think it's really important to recognize that I believe the Department of Health is overstepping its boundary in defining a bona fide relationship on the practice of medicine when it's the State Board of Medical Examiners' duty to do so. I also want to address the complications of the three things that you're asking a physician and patient to do, and explain the extreme burden and dangers of those three things. In the definition of a bona fide relationship, you're asking a doctor to, for one, get records from a patient, two, to do a physical exam, and to follow up sometime with that patient over the year, other than that's required by law. As far as follow-up goes, that's very clearly defined in the law to be once a year that a patient has to get a card. Why would I want a patient to travel across an island to pay me money to tell me they're doing really excellent with their medicine, simply because it's required by law? And this law should be no different in the definition of a bona fide relationship than any law, especially for controlled substances in the state. It should not be more severe than for morphine. And I prescribe, if I would prescribe morphine for a patient or other controlled substance, I don't need to get records on my patients for that. And if you've ever tried to get records from other doctors, you would immediately see the burden. And let me give you some complications that could be developing as a patient might not show up with those records. Well, first of all, what if I've seen that patient 10 times before and I have 10 years worth of records? What if that patient sent off to his doctor and his doctor didn't get the records to me in time, and that patient has plants in his or her yard, that am I supposed to say to that patient, please pull your plants, because I can't give you a card to get your medicine because your pediatrician back in high school who evaluated your scoliosis is now retired and you had a hard time getting those records. Are you going to put me in jail as the doctor because I didn't get those records and pulled medicine away from a patient because of that? So I think the idea of, in an idealistic world, of course I want to see records from my patients. I want to know everything I can about my patient, because I believe strongly and sincerely in a bona fide relationship, and I believe that every single patient I see would leave my office feeling that was a real relationship, what a doctor-patient relationship should be like. That's my goal with a patient. And that has really nothing to do with the records that I've gotten from it. It's taking it seriously, making sure that the benefits of using cannabis outweigh the dangers, and making darn sure that they have a qualification that they are swearing to me in the state that they claim to have. So there's a lot of difficulties with the record thing that needs to be worked out before just saying the doctor has to get records. Would they need to get it for recertifications of patients they've already seen and have records on? Did the patient need to get it from records that where patients and doctors might be retired, are being negligent in their response on sending the records? At what point is a livelihood at stake and the medicine itself not available to the patient? And these are things that I think the Department of Health is taking extremely seriously, because you're threatening doctors' livelihoods and patients' medicine. And so when you come to these decisions about the records, the physical exam, and the follow-up, please be very clear on exactly what level of records you want from us, whether we have to get records or our records count for having seen the patient before. So does this apply to new patients, to follow-up patients, recertifications, and the like of that? And please make clear of the consequences of not taking place. I also want to make clear that living on the Big Island, it's a very long distance and a burden for patients to travel, often 2.5 hours to come to see me in my office each way. And again, following up with the patient is a very difficult thing, especially if they're doing very well on the medicine. I just don't see a need to travel and spend a day to tell the doctor they're doing just fine. And if they're having challenges with the medicine, well, that's my obligation as a doctor. I make that clear to every patient. Please give me a call if you're having any trouble with the medicine, because it's my duty as a doctor to make sure that the benefits of the use of this medicine outweigh the dangers. And then lastly, the physical exam. Well, I think a doctor should be a doctor and define in his own life, because he's been licensed to practice medicine, the extent of the exam that he should choose. And if the state believes that a doctor is being negligent in his responsibilities, they should investigate that specific doctor and try to understand what it is that they're doing that is not a bona fide relationship. But the definition of bona fide relationship should apply to all controlled substances, probably all medicines in the state, or else it's not really a definition of a bona fide relationship. Because either a doctor's acting with sincere intent or he's acting fraudulently. And if he's acting fraudulently, that means he's purposely breaking the law to try to allow something to happen that shouldn't. And if you set up the qualifications to get a card just too restrictive in that way, I can assure you that it's just simply an arrow that the Department of Health would have to shoot at a doctor and patient and make it difficult so that at any time they can go get any doctor who's involved in this, because I can promise you that every doctor will not be able to get a record from every patient that they see, even if they have a sincere, beautiful, bona fide relationship with that patient. Thank you very much for letting me testify.
Thank you, Dr. Burke. Lee Smith-Meyer to be followed by Carrie Lawrence.
I have an immediate problem and then a kind of a question too. I recently went and got a paper from the doctor, but they say it takes up to 2 months for the card to actually come, and there's no number on here or anything like this. If the police come, they say this isn't good, but I'm paying for 2 months and it's going to expire. Once I give me 10 months, so 2 months I haven't been able to use or obtain medicine. I want to go get medicine today. I have this paper says I should be able to, but I can't. So that's my immediate problem. I'd like to get medicine today. What can I do? And then this question about the renewal. This is my own personal thought about the thing. Maybe there's some diseases that are so like I have Lyme disease. It's never going to go away, never be cured. Why do I have to go back every single year? Is it not able to get a lifetime card or 2 or 3 year card or something someday? I just was.
Excellent.
Well, yeah.
Okay, thank you.
So what would I do to obtain?
Yeah.
Can you talk to them afterwards?
Okay.
Okay.
Certainly.
Okay.
So there is an answer though. Yes,
Thank you. Excellent. We see her for the next one.
Carrie Marks to be followed by Cynthia Taylor.
Aloha, good morning, and thank you for coming and thank you for hearing us. I know I'm not supposed to talk about medical dispensaries or legalization, but I'm going to mention it because I want you to be in that frame of mind while you're promulgating rules. That this is a great first step, but it is a first step. This is not the final form, and this is not where this issue is going to end up. So I want you to be prepared for the future, because we are still advocating for full legalization, which will do away with many pages of your rules, especially all of the law enforcement stuff, yeah? So that would be the first easy way to fix all your law enforcement problems in here.
Oh.
I hope, because it is a problem. There's a serious stigma still attached to this program. Even though it's been taken over by you lovely folks at the Department of Health and it is now being treated as a medical situation and not a legal situation, mostly. But as we've already heard this morning, that's not the case still. There's still a big stigma attached. So we have to keep pushing this issue, and we have to keep pushing you further than maybe you're comfortable going. Okay, my main concern is with subchapter 3 about the debilitating medical conditions and also the physician requirements. The whole requirement that it be your primary care physician is incredibly problematic, especially on the outer islands. I don't know if you've ever lived on an outer island and tried to find a primary care physician, even one that doesn't want to give you a medical marijuana certificate. It's incredibly difficult. We don't have enough physicians here to begin with, and we certainly don't have enough that are willing to be primary for that and run a pap smear and see your sick kids and all that kind of stuff too. So this, I believe, is a payer situation. It's more than really you need a primary caregiver on task. This is involving the insurance companies. So we need to change that right now. The medical records, I had a whole bunch to say, but if you just want to take everything Dr. Berg said and insert those words as my own, that would be awesome. Medical record patient confidentiality is a serious issue. I have worked in medical records pretty much my entire adult life. That's what I do. Okay? It was my job when the subpoenas come in for the court cases, for the car accidents and all that kind of stuff to pull the records. It's an incredibly time-consuming and labor-intensive thing to keep medical records and to just be at your beck and call every time you need something. So you need to take seriously those considerations and make sure that what you're asking for is actually required and needed. I also am very concerned about your asking for medical information to give to law enforcement. It's a huge, huge problem. There are 13,000 medical marijuana patients in the state. There should be 113,000 easily. But most people, myself included, are unwilling to put myself out there like this. I don't want to be on a list. I don't want to be on a DEA list. I want to apply for a job someday and not have this come up. There's a million reasons that people will not go through these hoops to do what we're already doing and have been doing for 10,000 years, medicating ourselves. Okay? The caregiver thing is a huge problem. Most people can't grow it themselves. I am actually an enormously successful tomato farmer. Absolutely failed at growing any sort of marijuana. I haven't tried recently, but I did try many, many years ago. It's really hard. It's more than putting a seed in the dirt and watering it every once in a while. There is this huge chemical thing that goes on, and then there's budding and light cycles, and I don't even want to learn it. I don't care to learn it. I just want to be able to access medicine. Okay? Those that can find a caregiver, caregivers are limited to one patient. Get over yourselves. How many avid gardeners do you think there are on this island, or any island? You can't do that. It's absolutely, it's silly. Enough about that. The stigma, I went on about that. Fear of prosecution, we said that. Dispose of at the police station? You really suppose that's going to happen? Not in a million years am I driving up to the cop shop with my half a bag of pot for them to dispose of it. Again, I'm not putting myself out there like that. This is a medical issue now, no longer law enforcement. Let's get with the program. Okay, 2 months to obtain a permit. Do you have any idea how long it takes to grow a medical marijuana plant? Months. So I get my permit today. When can I actually use my medicine? Not for a long, long time, and that's if I'm successful. So, back to the whole dispensary legalization issue. A lot of these problems would be dealt with if we just thought bigger right now. This has been 14, 15 years in the making. We cannot wait another, people aren't waiting. They're not waiting. They're doing on their own anyway. So it's time for the state to get with the program and get with the people and do what they need to do to take care of people that are trying to take care of themselves. Mahalo.
Cynthia Taylor to be followed by Nancy Harris.
I'm going to pass. I wanted to speak about dispensaries, but I know that's not your primary concern.
We can maybe talk afterwards.
Okay, thanks, Ms. Taylor. Nancy Harris. To be followed by Brittany Neal.
Aloha, I'm Reverend Nancy Harris, and thank you for putting all this work into these rules. I have to tell you that as a patient, some of them seem punitive. Particularly section 11, 16046, where it talks about, it's subchapter 7. it talks about monitoring and investigation. Right, the first sentence, the department may at any time contact a qualifying patient, primary caregiver, or certifying physician by telephone. Okay, I can take a call anytime. Mail or in person. Does that mean that the Department of Health, any time of day or night, Christmas dinner, can just come up to my home and see if my medicine is accurate? Do you do this for Schedule II substances? Do you do this for cocaine, which is a Schedule II substance and can be prescribed by Dr. Bird? I think it's kind of, that seems invasive and punitive and like it was the Department of Public Safety and not the Department of Health. And also in that same section, B, it says that if the department is unable to verify the current accuracy, they may revoke the qualifying patient's or primary caregiver registration. Now, I can see that there would be a time where that would be appropriate, but certainly if you're going to have that regulation, there should be something about notification of the patient that it's going to be revoked before it happens so that they can deal with it appropriately and not have something illegal in their home and be revoked in Honolulu and not know. And again, still subchapter 7, the ability to, the department, when it has reason to believe a violation of any provision of this chapter or part 9 in chapter 329 has occurred, may either conduct an investigation, so now they sound like police again, to collect the evidence of a violation, or notify the proper state or local authorities. Again, that sounds very punitive, not what would happen if I had a prescription for pain pills that was certainly a lot more dangerous and inappropriate in a way of dealing with patients. And I'm not saying that there would not be current occasions when that would happen, but I would think that step 1 would be to have open a dialogue with the patient or caregiver or physician before an investigation. Are you going to have your own health department cops? Right. So maybe something in these rules that suggest that a kind of dialogue was going on would be extremely appropriate. And I think my time is probably about up. Thank you for listening.
Okay, thank you, Rick. Next, Brittany Neal to be followed by Brenda. Here. Okay, Brenda, okay. Yeah, some like, looks like a pen was running out of ink, so. Ms. Neal, go ahead, when you're ready.
Okay, thank you. Let me just find one section. Okay, so first of all, I just want to take a moment to thank you folks for coming here today to listen to us. I really appreciate your perspective of getting the folks who are the most affected by these rules involved with where they're headed. So thank you. First of all, I would just like to offer up that if these administrative rules were to be revised, taking into consideration the Department of Health's mission statement, and they focused a little bit more on protecting and improving the health and environment for medical cannabis patients and caregivers in Hawaii, I think that would really go so much further. And specifically to incorporate the 5 A's that are mentioned on the Department of Health's website under the mission statement. And they've been identified as goals that are important to assure basic physical and mental health care be addressed. And they include affordable, appropriate, assured quality, available, and accessible. If those 5 A's were addressed in this administrative rules, I think that it would be fabulous. Furthermore, one issue that I found with these administrative rules has to do with section 11-60-40, disposal of unused marijuana. So this is specific to when a card has been revoked or otherwise void. I would like to see it also encompass when a patient has excess marijuana. Because if the law defines that a patient cannot have more than 4 ounces of usable medical cannabis, we need to have a way to get rid of it in order to comply with the law. Otherwise, it seems tantamount to entrapment. So if that could be addressed, that would also be huge. And then just one more thing that I'd like to say is regarding section 11-160-8, department approved conditions, removal or modification of conditions. I think that the process that you folks have come up with to actually approve new conditions is very thorough, and I'm glad to see it in there. But given its thoroughness, to say that one person, the director of health, can make a decision to remove a qualifying condition that has only gotten there because a person's medical doctor has said that they would benefit from this medicine. They submitted research. All of these hoops that you folks have created are great, but I don't think that conditions will need to be removed once they're added, especially not based on one person's opinion, who is a medical doctor, I understand, but their opinion doesn't outweigh that of all other medical doctors. That's all I have to say for today. There's so much more. I appreciate this opportunity. I'll submit whatever I haven't mentioned today later in writing. So thank you.
Thank you.
Okay, Brenda, to be followed by Michael Hilo. Ayala,
Aloha and welcome to Hilo. I want you guys to know, ladies and gentlemen, that I'm really happy you're here. This is very important to us patients in this state. I also want to apologize for my outburst earlier, that I understand that this is a public location and a public meeting, but I think there needs to be a little bit of sensitivity to patients that are here. I don't know if that violates HIPAA, but I really think that a little more sensitivity needs to be on the table. I also want to lodge an additional complaint for lack of information available about this meeting on the Department of Health medical marijuana site. I could not find it. I don't take the newspaper. I called 3 activists and they didn't know where this meeting was. They heard by mouth that it was going to happen. Second complaint is inadequate copies of the agenda and proposed changes. I would be happy to comment on individual issues, but I'm going to have to make some generic comments about what I've heard. First is, I would like to recommend that the State of Hawaii Department of Health look hard at the Oregon medical marijuana program. They had, and yes, they had it from day one. I appreciate your reinventing the gopher wheel here. But they had an excellent program. They expanded that program and greatly improved their HIPAA, creating private areas where a patient could turn in their paperwork, and their process, the patient was responsible for taking their recommendation and paperwork, taking it or mailing it to the State Department with their money, taking that, paying their money, and the moment they got their receipt, they were legal. If they chose to walk it through the system, they were legal from the moment they paid. This puts a tremendous amount of onus on the physician. Patients can be responsible. A patient is required to go to their pain management physician every month and pick up a prescription to take to their pharmacy for Schedule II controlled substances. Well, we're not a Schedule II controlled substance. So I just wanted to bring that up. Take a hard look at Oregon's management program. It was beautiful. I was a patient there for 3 years before moving here in 2009 and was aghast at the hoops that had to be jumped compared to the hoops there. Okay. The compliance issue. Do you do compliance checks on hydrocodone or oxycodone? Do you come to my medicine cabinet and take a hard look at what I've got in my medicine cabinet? Are you allowed to check my purse when I'm in public? No. No compliance checks without a warrant. And until you change the law for oxycodone, hydrocodone, the other scheduled and 2 and 3 narcotics, don't touch marijuana. Okay? Plant labeling. Am I required on the pills I carry in my purse for my narcotics to have that in a legally registered bottle? Am I required that when I step on an airplane, even by TSA? No, I'm not. I should not have to have my marijuana registered, legal, properly paperwork, properly tagged outside of what exists. I could see it as a recommendation against theft in an attempt to get a person's stolen property returned. Again, look at the Schedule 2 and Schedule 3 narcotics for what is allowed, and anything beyond that is overstepping the bounds. I realize that most of those are DEA requirements, and so I'll leave it at that. This is not a DEA drug. Okay. Lastly is, I'm going to suggest, again, look at Oregon. Prior to the change of their law in 2007, which greatly expanded the number of plants available, etc., which were expanded to a total of 24 with specific limitations on quantity of size. Prior to that law going into the effect, the feds and the state of Oregon hashed it out. The feds said as long as one caregiver, we call them care grower, has less than 99 plants on his property, we don't care, supposedly. Okay. Why can't the state of Hawaii look at the federal requirements as imposed on other states? And yes, I know I'm getting out of the meeting intent here. But take a hard look at what other states have done for that, because it's out there. And it has been, and those states have jumped hoops to at least attempt to keep the feds happy. So anyway, that's my comments, and again, I thank you very much for being here. And I will attempt to file this on.
Michael Aiello, followed by Mike Ruggles.
Thank you for being here and allowing me to speak. I have some very short comments to make specifically about the administrative rules. And some other people touched on the section 11-160-46, monitoring and investigations. This is pretty evidently a violation of privacy, and it's an unconstitutional violation, and it suggests that this section grants authorities the ability to visit medical marijuana patients in person at any time. That's a quote directly from the proposed rules. This is basically compliance checks, and medical marijuana patients do not give up their rights to be, they don't give up their rights to be free from arbitrary searches and seizures. And then secondly, and maybe more importantly, is a recommendation that isn't in the list of administrative rules, and that should be that we should change the term marijuana to cannabis in all Department of Hawaii Health Documentation and Communications. The term marijuana is a meaningless and outdated term with an unsavory racist history. I think it's time for us to get rid of it. And those are my 2 comments. Thank you.
Morning, my name is Mike Ruggles, represent the Alternative Pain Management Collective. As you notice, there's a lot of problems with your administrative rules. But first off, before we get to them, I want to point out, as Lee pointed out, that right now you guys have a 2 months backlog. If you look at your administrative rules, the ones that are current, that you're supposed to be following, in it, what it says is, upon receipt from the doctor, NED, which is now you guys, are supposed to issue a receipt that serves as a temporary. So please look at that and start doing that so that people like Lee, when he gets his card and he gets a letter, he'll get a receipt from you guys, because it says right in there, temporary receipt from NED to serve as your temporary card. Then it says further, if the new card doesn't show within 30 days, you're good. It says that in the current rules you guys are following. So please start doing that. Let's start issuing temporary receipts. And while we're on that subject, the 2 month backlog. You'll notice we're in the health department building. It's 2 stories. There's 50 doors. This is the county. Why can't the county issue cards to the people in the county? How come it has to be micromanaged from the people in Oahu? Furthermore, the director, hey, that's great. Why is the director, there's going to be this 13,000 and climbing, 15,000 people. You mean to tell me everything is going to have to go across the director's desk in order to get signed or approved? Every petition? And then in the end, how can the director, I understand the director's a doctor, but how can they override the doctor like Dr. Berg, who has actually seen the patient? How can a guy who's never seen the patient say that he has better knowledge than the bona fide doctor that has seen the patient and recommended? That's ridiculous. Take that out of there, guys. Let's see, where else are you? Oh, the cards. It says on your website, if you happen to have your card on you when you're traveling with your marijuana, show it to the officer and you can be on your way. The problem with that is the card has to be at home. What if they show up with these anytime compliance checks and your card ain't home? As Brad has pointed out, if you don't have your card, they take your marijuana. It's that simple. All right, let's go to compliance checks. I'm currently suing the county for doing a compliance check. I can tell you how it says in the Supreme Court. It says the right to privacy is too valuable to be left in law enforcement. So what that means is that unless they can get a warrant, show probable cause to a judge, they don't come on your property. Currently what they're doing is they fly overhead, which I think is illegal as well, notice you got marijuana, and then they come up your driveway with the SWAT team. If you don't have your card with you at the time, like at the time Brad, they took his pot, he had a letter from the doctor. They said, sorry, letters don't work, only your card. And they took his marijuana. He's suing them, I'm suing them. So you can't do compliance checks, guys. I'm just letting you know. If you get that, pass that in the law, I will sue you guys. If you don't change these administrative rules, I'm going to sue you. Let's do a quick little history lesson. In the year 2000, they passed Act 228. In it, it said, compassionate, uninterrupted use for cannabis. What happened then is you guys came up with 329 and your administrative rules. And what came out of that was 7 plants, 3 ounces, stand silent on how you acquire, affirmative defense, and guess what that's led into the courts? That already went up to the Supreme Court, Gonzalez versus Rack, and it says irreconcilable inconsistencies. So what they're saying is that the current one of these had irreconcilable inconsistencies with the law. That's why they overruled all that. So my point is, we're not going to let you guys get away with that again. That's already been termed legislative malfeasance.
That's right.
That's already been, that's what they call medical marijuana program right now in the state of Hawaii. And if you guys can tell me how this administrative rule is, like she pointed out, the 5 points, affordability, accessibility, how are these helping in any way, guys? What you have here is a wish list for law enforcement. Obviously, as the doctor pointed out, you guys are attacking the doctors. You're trying to make it to where if a doctor doesn't see a patient more than once a year, you can go after the doctor. That's ridiculous. Why are you attacking the doctors? You're the health department. You are doctors. You shouldn't be attacking the doctors. you shouldn't be attacking the patients. What are you talking about compliance checks? Before, you know, as the guy pointed out, you can only have one caregiver per patient. What I was doing is I had a caregiver, I would sign away that caregiver. She'd say, Mike's no longer caregiving for me, he's caregiving for Brent. And then before they would leave, we would sign it back. Well, you guys have, we'd come up with a legal way of transferring medicine amongst medical cannabis. You guys now, in your new rules, say, no, if you do that, you gotta wait 10 days. Why? Like, I got somebody with pancreatic cancer. Why can't I sign them on as a caregiver? They might not be around in 10 days. And then you got your backlog, 2-month backlog. And you've already said, if you change caregivers, you can't give them care until you get the card. So now it's 10 days plus 2 months, that's 2.5 months. The guy with pancreatic cancer is gone, guys. Why are you stepping in between patients and caregivers and making it even harder? These administrative rules, guys, I understand you needed to have some input from law enforcement. But come on, this is a wish list for police. You can go after the cops, you can go after the patients, they can come on your property anytime they want. Why are you attacking us? I don't understand. Are you trying to kill the cannabis program? When the rest of the country is going the other way, these changes that you guys are recommending effectively will kill the program. This isn't going to make anybody want to join up. When the cops can just come on the property anytime they want, day or night, it's unconstitutional, it's ridiculous. And why don't we put in some good changes? Can't you guys come up with a way of determining dry? It says we're allowed now 4 ounces of dry and usable. You know, I talked to the police chief here on the island face to face. I said, hey, if you come up with a scientific way of determining dry, he said, no, it all depends on whether we think you're distributing or not. Well, I can tell you guys this, marijuana is 15 times heavier wet than dry. When the cops come on, when they came up to my property in 07 and I got busted, I had some pot hanging, they weighed it and decided it was 2 grams over what I was supposed to have. It was hanging there wet. I got busted for a Class A felony. They tried to give me 20 years for having 2 grams too much medical marijuana. I've been in this fight since 07. Come on, guys, this administrative rule, let's get some input from the health department. Obviously, you guys didn't make this up. You guys don't want to attack doctors. Why are you stepping in front of us? And the compliance checks, utterly ridiculous, unconstitutional. You will get sued. If you try to promulgate this as it stands, I'm going to sue you guys. I'm going to try to get an injunction so that you can't even present it to the legislators. Because it's ridiculous, and it obviously doesn't have your input. And in addition, if you can have them come anytime, day or night, you know there's no legal way for medical marijuanas to obtain what they're using, whether it's clones, seeds, plants. If they don't have extra, when they run out, how are they going to get a new one? So my point is, unless you guys give us access to legal ways of acquiring it, to make it to where you can come check to see if we're doing it legally when you know there's not one person in the state doing it legally, that's entrapment, guys, and it's like shooting fish in a barrel. How can you just come up anytime you want, unannounced, and say, we want to see how you're acquiring your medicine and we know it's illegal? Come on, guys, that ain't going to fly. I'm going to sue you guys for that. Don't do it. Come on, you can fix this. And in addition, put in, when are clones clones? Right now, the police say clones are clones as soon as you cut it off the plant. Come on, you got to have plants. Seedlings are called seedlings because they're not plants. At least give us the ability to have some seedlings in addition to our plants, the ability to have some clones, so that now when we go out and illegally purchase our stuff on the black market, at least we don't have to go back. At least we can continue to use the ones we've been using, either in the form of clones, seedlings. Why do we got to go back to Momo Street and try to get better clones? Just last week, last time I got clones, every one of them horned up. I don't know if you guys know what that means, but it means it's a male and a female that makes seeds, and it makes the cannabis way less quality. Because, hey, you don't know where you're getting them. People tell you, hey, this is good. It's not good. All right, my time's up. I appreciate you guys.
Preaching to the choir.
Okay, that's everyone who's indicated that they wanted to speak.
Are you still in the back?
But if there's Well, on the initial sheet, if there seems to be another sheet
I
around, let's
mentioned
get
it, I
that
would
up.
speak if I saw how it went, because I just didn't want to talk, and people just.
Okay, and I didn't want to embarrass anybody who wanted to see how it went, so you want to be on?
I
Okay.
can say something.
You're see how it goes? Okay, all right, this Thomas McGovern first, and then we will go to the sheet, which is Devaki Clark.
I agree pretty much with all the comments prior. Time Magazine did an article about 3 years ago on medical cannabis, and they revealed that the big companies know that some pot makes you sleepy, some makes you hungry, some takes the pain away. What they want is for us to buy it from them, and they don't want us to be able to be capitalized. Think about that. The Oregon model is great because it includes all level of economic benefits to the communities. Think of all the money that you're missing here in terms of dispensaries. As someone mentioned earlier, Hawaii is almost like a time travel. I came from Ann Arbor where in 1974 they had the $5 pot law because college professors didn't want to see their children turned into criminals so that they couldn't go away to college. They'd have to stay at U of M. So this way they could ship them off to Boston. I'm sorry. Anyway. As far as the cops, I mean, we know they fly over before Christmas and take our weed and give it to their friends. I mean, this is just part and parcel to what we have to deal with. And as far as the definition of plants, we learn in first, second grade, small p, large p, capital letters, small letters. I think the requirement should be, if you want to only limit to 7 plants or anything like that, there's some kind of quantity where you're talking about what does a mature marijuana plant capable of. And we know they can go 18 feet tall. Just because you can only grow 7 little dinky ones and you'd like to have some weed, some medicine later on, you need more plants. So this is really critical. Mike once mentioned to me it takes, what, 12.5 pounds of wet to get how much?
1 pound.
Yeah, 12.5 pounds of wet weed to get 1 pound. And that's not even medical grade, that's just a pound of. And if you're talking cannabis levels and stuff, by the way, there are available commercially now little devices where you can like put your weed in and find out what the concentration of the THC and stuff. So, okay, a little bit what are my other notes? The thing about the cards and the lifetime thing, I think that's great because a lot of us are here because we're on Social Security. You know, I had a doctor who said, you know, something's wrong with your head. It's going to get a little better, but you're not going back to work. You know, so that kind of means you're at home, and it looks like a money generator for a lot of us. You know, especially in light of getting the cards late. You've spent $100 for the doc, you paid for the card, and now you're not getting your money's worth. So, thanks.
Okay, Devaki Claire to be followed by Mariah Ancona.
Good morning. My husband has a skin cancer. It ate half of his nose away. A big tumor grew and went up into his eye. And he started radiation treatments. We had to come into Hilo every day, Monday through Friday, for 8 weeks for him to be radiated for this cancer. And it would have been very hard for him to go through this radiation if he did not have marijuana, cannabis. It has made it tolerable for him. And there are many people who really need marijuana as a medicine, and they shouldn't be having any problems to get it. And my husband is also a grower, but he cannot grow enough to cover just what he needs. Because you need a lot of cannabis for cancer, especially and other things, more than what we're allowed. And then cannabis should be treated like the Hawaiians treat taro. It's a very sacred plant, and there should be no restrictions on it. The biggest problem I see are the rules that people come up with. The rules, to me, looks like it's just a
continuation of the war on people who use marijuana, known as the drug war. And I would like to, I agree with everything what everybody else has said, and I think these rules should be changed. There should probably be no rules. There should be no amount of care, no limit to caregivers and patients, because people need this medicine. And it's probably time to just legalize marijuana and just not make those rules. So people can grow this medicine, it's very needed. That's really all I have to say.
You know, I met your husband several months ago, just had a really nice connection with him. If you give my best, I appreciate that.
Tomorrow is his last radiation treatment. It's been very hard on him the last week, but he's endured it because of cannabis.
Thanks for coming.
Mariah and
Sorry, I'm late because I came to Kona, so it's kind of a journey to get here. Never testified like this before, so I'm not sure how I should go about it. Just explain my point of view on medical marijuana.
This hearing deals with the regulations that are being proposed with respect to implement medical marijuana now that it's been transferred to the Department of Health. These rules are proposed to replace the rules that the Public Safety Department had. And so we're gathering testimony on today is the newly proposed, the regulations that are proposed
That
to replace the
article.
old ones.
They're in that book in front of you there.
Yeah. Yeah, I looked at this. I think it's pretty much, it's a lot similar to the old law, right?
The law is the law.
Because I have been using medical marijuana for 5 years, and it's gotten me off about 14 different pills. And I started pills at 6 years old. I was prescribed, and I don't think that regulation is such a bad thing. I think it's a good idea, because we have a need for weed in the community, and sometimes growing it is not the best option, because then you have people stealing it from you, like me. I'm constantly going through that with my medical. Like whenever I grow, like I go out and I'm like, where are all these branches going, you know, and things like that. But if I could just pick it up at a pharmacy, like that's how it should be. I don't think that it's right that we're sick people that use it, and we have to grow it, and we have to keep it a certain amount, you know. It's hard to do that. And especially, I have ovarian cancer, and I've also survived spinal meningitis and leptospirosis. Marijuana is like, saved my life. And right now, CPS, something needs to be done with CPS and marijuana. People that use marijuana, like me, I don't have any custody because of it. My child. It's not dangerous because I smoke weed or eat weed, you know. And I don't think that that's right. I think that's something that should be changed, the way CPS deals with people. I think that patients should have access to weed and not have to go to a drug dealer, you know. And do you know how expensive weed is nowadays? In the past 10 years, it's 40% more expensive. In 2004, I even smoked. It was very cheap and easy to get. Now it seems like since it's become legal, it's hard to get. It's hard to find the right kind of weed. Like, I have nausea every day. I wake up puking. I've had a lot of organs removed. So, you know, I can't be chasing it around and growing it all the time. You know, I think that we need a pharmacy, a dispensary. Really needs to be open. We hear a lot of talks about it, but when we're going to see it, don't you think the cops are going to be shutting it down all the time? Like, and that's another thing that needs to be changed, is the way the police interact with medical marijuana patients. Because I've been beat up just because of smoking a joint in my apartment. Like, that's what my scar on my head was. Cops came and assaulted me and took me to the hospital, dropped me off. All because someone complained they smoked marijuana. things like that. It's not, I don't think that that's right, and I know I'm not the only one that goes through horrendous things with weed.
Thank you for your testimony. Okay, that's everyone who's indicated that they wanted to speak. Is there anyone else in the audience who wants to add something?
I came in late, I'm sorry if I missed most of it, but I'd like to say.
Okay.
My name is Rex Weil, I'm a chiropractor in Hilo. My concern today is with accessibility. When this first came out last year, I heard that it was going to be only attending physicians or primary care physicians that are going to be able to prescribe it. My question would be, first of all, most primary care providers don't want to do pain management. I suppose that's been brought up here. But like I get a lot of people that are injured in accidents and at work, and physicians don't want to take that either, medical physicians, so they send it to us. So my question would be, if a patient needed medical marijuana, could I refer them to somebody like a pain management, pain clinic like Dr. Powell's clinic, and he could prescribe it, or does it have to be the primary healthcare provider for that patient?
Okay, for questions, individual questions like that, the folks here from the health department will be from the medical marijuana can answer those after the meeting.
Okay.
That's what we're doing here, is gathering testimony on the proposed regulations that have been proposed now that the medical marijuana program has been shifted into the health department to replace the old public safety rules with the new health rules.
He's touching on
Okay,
the
well,
primary care
my
responsibility.
question is that if I want to get medical marijuana, does it have to come from my private health care provider, or can it be a specialty provider? Because that's what I'm confused about this, is it seems like they are trying to tighten the noose on that in terms of accessibility. If my primary health care provider doesn't want to do pain management, and some don't want to do any kind of pain management, can I be referred to somebody that does that? That's what I'm confused about in this. You have this primary, 7 different descriptions: primary care physician, you're only qualifying medical doctors, which in work comp would preclude everybody but medical doctors. But I don't want to prescribe it. I just want to know, how do I get my patients to those physicians that will prescribe it? It seems to me like it was, when it first came out, it sounded to me like they were trying to narrow it down to just your doctor. When their doctor doesn't want to take them on a pain management basis, then what happens? The other thing is that it seems like we're still in the Stone Age when it comes to providing this drug to people, or this modality to people. If you're going to get an opiate, they don't give you permission, the state doesn't give you permission to grow poppies, and you don't have to go to an alley on Hotel Street to buy it. And it's still, you know, Hawaii used to be the mecca of marijuana growing. I mean, we've got 2 or 3 seasons a year we could grow marijuana, but if somebody's living in a condominium, it's kind of difficult to grow marijuana, and I don't see how that makes it that accessible. It doesn't seem like these rules change that. And I was hoping at some point we would come around to where they are on the mainland now, and having places where you can go to buy this without having to go out on the street. So those are the couple things that I noticed. The accessibility in terms of getting the product is still the same, but it looks like what's changing is who you go to get that prescription. Because there have been people around that I could refer my patients to and they could get that. Now it doesn't seem like, I'm unclear as if I can still do that. Pain management doctors will take patients, but my question is, will the Department of Health let them prescribe marijuana? That's what I don't know. So that was the reason I came today, just to see if I could get clarification on that. So that's all I had to say.
Thank you.
Okay, anyone else?
Yeah, I do.
Oh, okay, why don't,
Real
So
fast.
she's on the way up, and then you, okay. I know you just came in, there's a sign-in sheet too, if you could sign in, and then we can, so we have your name in there. Earlier on, for those of you who came in later, the dispensary question is not part of the subject of today's hearing. That is being considered as a separate matter, and
Yeah, just maybe I'll say a few things. There are at least 2 bills that have been introduced already this year in the legislature for dispensaries. I know there's a huge concern and interest in dispensaries. I would suggest that you look online, go to the state legislature website, and you can just type in medical marijuana or medical marijuana dispensaries. I know one of the bills is HB 329, and that is a bill that is being proposed by, based on the recommendations of the group of people that came out here about 3 months ago. And I think many of the recommendations that came from the people in Hilo and a similar hearing on Oahu are in that bill. So it's clearly an issue about accessibility. I mean, your point is very well taken. The legislature is looking at it. You know, in previous years, there's been a push for establishing dispensaries. The law has not changed. It looks like this year there's a greater likelihood of the law changing. I'd encourage you to look at the law, and you can send in testimony for those hearings. It's really important when legislators get to hear from people. And I tell you, the people in Hilo, you folks here and the folks that I met 3 months ago, make very, very compelling arguments. I want you to know how much we appreciate and respect your personal stories. And I gotta say, I felt very moved, and everybody that came out here 3 months ago was absolutely changed and moved by the testimony that you and, you know, that your husband, when he came here and gave his testimony. So feel empowered to continue that. I know change doesn't come just as fast as anybody wants it, but the opportunity for dispensaries and greater accessibility exists if laws are passed. And it's not through administrative rule changes. Administrative rules are based on laws that are passed by the legislature, so continue to get involved and look at that.
My name is Kathleen, I'm married to Robin, and I totally disagree with having marijuana be upon our land. The reason for this is I lost my dad when he was 48 years old. He died of liver cancer. Then I lost my brother-in-law at 65. He made the geothermal rig out there, and he was totally dependent on marijuana. You know, he owed people so much, thousands and thousands of dollars. You know, and marijuana took his life. So because of that, I totally agree that we should not have marijuana be a part of our state. Marijuana is a product that will change your whole ability of thinking, of eating, of functioning. I mean, yet our legislature wants people to be dysfunctional on the road, applying their vehicle, using marijuana. I think that marijuana is a product that needs to be totally removed from our body. I work for Easter Seal, and I know that there are people in the community that does use marijuana. But would you like your child to be using marijuana?
Alcohol.
Do you all want your children to use marijuana? Marijuana
Okay, well,
will.
everybody can testify on this as they have wished and they wish to, but let's let each witness be able to testify.
As a teacher, I totally oppose marijuana because it will change our youth ability to function.
Yeah, they might run for president.
Is that an opinion or is that scientific-based fact?
Wait, excuse me. This is to hear testimony, it's not to be asking questions for other folks that are
But is it on the
testifying.
administrative rule? I'm not
I
sure we're on
I
the
don't
same
care if
page
it's an
here.
administrative rule or it can be the United States rule. But marijuana will dysfunction all of our children and all of our people of Hawaii. So with that in mind, I want each of you to examine your own conscience and think about what is marijuana. And that's it. This is all that I need to say. I wish they would put it in a poll for us to elect as citizens of the United States to have this product be legal.
So do we.
Thank you for your testimony. And again, some of these questions that deal with the legality, write your legislators with your decision. Sir, you want to testify? The gentleman in the back who wanted to testify before. Have you signed in? Okay.
Hello, my name is Brian Lawler, and I'm a transplant here about 7 years ago in Hawaii. And I've been smoking marijuana since I was a young gentleman. Basically, I got ran over when I was 13 years old and had numerous damage to my lower extremities. And because of it, I needed something besides pain pills because all I did was sit around and slobber on myself. So I started using medical marijuana 7 years ago when my doctor referred me to it. And it's done a big help for me. But what I was really reference today is there's two things in here that I don't really care for in the bill that I'd like to bring up. Is one, the tagging of the marijuana plants is very, very hard to do because the tags fall off, the numbers fall off. We've tried hundreds of different things over years and it's really hard to do. So that's one of my things I wanted to mention that was in the bill. And the second one was the accessibility for the police to come to your house after hours. From light to light, my house has always been open because I grow my own marijuana. But after 7 o'clock at night, everything's closed up. I go in the house, I'm with my family then, and I don't really think it's right. They should be able to go in your house 24 hours a day, pull your kids out of bed, and I've had this happen, pull your kids out of bed in their underwear and stand around while they actually look at your pot plants and then they turn around and leave and you're embarrassed. It's really a hassle for the family, so that's kind of just what I was trying to address. I think is a 24-hour basis they can walk in the door is not really fair to our rights. It's just basically what I say. Any other time, I'm sure anybody in this room would be welcome to open their doors to anyone from light to light. But after that, it's basically, I think it's an infringement on our rights. So, but that's about all I got to say. Thank you very much.
Okay, I think that's everybody's right. Okay, one more. Okay.
Sorry, I'll be fast. Hello, my name is Brent Neal.
We'll get you on the sign sheet, it's okay.
One thing I just wanted to mention was the labels once again. I'm really nervous about you guys just having arbitrary of how a label should be and then us expected to follow it. So if you guys are insisting on having a label, my suggestion would be that you guys create the labels and then provide them with the blue card. If you have to have them, I think that you shouldn't. Another thing would be chronic conditions. I have chronic conditions and nerve pain, so my condition's never going to go away. And a lot of people, you know, to have a medical card, a lot of them are debilitating life conditions. And so it doesn't make sense that everybody has to re-up and do this whole loophole, jumping through the hoops every year. Possibilities of, everybody has a possibility of having a couple months in between where they could be, you know, possibly a criminal. And if something's not going to go away, I think a doctor should have the authority to be like, they can have a prescription for 5 years, 10 years, for the rest of their life. If they know their condition's not gonna change, there's no sense to have to re-evaluate the patient every year. I personally see it as two things: a racket for you guys to gather money from us, and two, a loophole to always have ways to bust us. Another thing would be that the doctor should have a personal note on your card of, if he thinks that some patients 4 ounces might be adequate supply for some people, especially if they're using flour and there's nothing else. But if people have chronic pain and they're using edibles or oil or all these other things, sometimes you need 15 pounds to make 1 ounce of oil for yourself. And there's no way to keep an adequate supply. And the original spirit of the law and the true intent of the law was adequate, uninterrupted supply. I think that's very important for everybody. And so if the doctor is able to, like I said, some patients need the 99 plants. Others might need just the 7. I think the doctor should have the authority to say, like with anything else, the doctor can give you 10 milligrams of Vicodin or 80 milligrams of Vicodin. It just depends on what you fit. And then another thing would be square footage with plants. A plant can only make so much bud per square foot. And there's actually a calculation that you can figure out on this. And so I hear about all these people, oh, the biggest drug bust ever. And then you actually look, and they had 4,000 seedlings that are this tall. And it's like, really? I mean, it's ridiculous. And so if people can't count the 7 plants that are, figure out the whole maturing and stuff, well, maybe we should throw out that everything is just, you have a certain amount of square footage for budding. It doesn't matter about vegetation, because vegetation, you can't do anything with it anyways, and it's not held against you. That would, I think, take away a lot of the guesswork. I think that's what they were doing in California, actually, because a lot of the people, the police couldn't figure out counting plants in this whole thing, but they could figure out the square footage. It's still going to produce, you can grow, the amazing thing is you can grow 1 plant in 10 square feet, or you can grow 1,000 plants in the same amount of 10 square feet. It's going to provide the same amount of medicine. So, just stuff like that. I guess that's it. Thank you.
Okay, thank you very much.
I'm sorry.
Thank you, Mr. Moon.
Interrupted.
Okay.
Thank you.
Anyone else?
I do have something I forgot.
Okay, sir.
And this is off topic, but I hinted on it.
You
The
didn't tell me that.
marijuana, the 1972-74 pot law that they had in Ann Arbor. I checked with my friends a couple of years ago when I was associated with Peaceful Skies, and it turns out that, well, yes, at that time, prior to the whole medical movement nationwide, the DEA was busting people in Ann Arbor that had large amounts. But I want to note that they weren't pulling these people out of their house at night in their underwear or naked. The brutality in which the Hawaiian police have been handling this situation has not even really been touched upon today. I know a woman personally who was taken out of bed at night, not permitted to dress, had to go to jail naked. Now this is heinous. This is, to me, it's a war crime, you know, when you consider the whole Hawaiian politics thing going on. But, so we would hope this would go away with the medical marijuana, but as the people are mentioning today, this is the kind of fear we have to live with, especially in Puna. Okay? And we know that they're giving this stuff to their cousin. So now, can I prove that? No, because I might get beat up. So I'll leave it at that.
Thank you.
Question. Can we ask a question?
Afterwards.
After the meeting. I noticed there's Rex Weigel.
Yeah.
Oh, okay, we have, you did speak. And then there was a Kathleen?
No, she did.
She did speak?
Yeah, I
She
got
spoke
her
also?
as she was
Oh,
up there.
okay, okay.
Was there anybody else though that we missed?
Okay, all right. Okay, now seeing that everyone's done, thank you so much for your participation.
Thank you.
Are you closing it up because I want to?
Yes, yeah, you can bring it closer. Thank you. Thank you for all for coming and participating today. There is an opportunity, again, to submit written testimony, if you wish, until February 6th at 4:30 p.m. to medicalmarijuana@doh.hawaii.gov or at 4348 Wailea Avenue, number 648, Honolulu 96816. For those who want to add to their testimony or put in testimony that you haven't, if you haven't spoken already.
Specific to these regs. though, right?
Specific to the regulation, yeah. And again, on the legislative things, the legislature is in session. If you have comments on any of these things the legislature is considering, or you think that it should be considering, even if there's no bill, send them to your legislators. Anything else?
We're going to be around here for probably about half an hour, so we're willing to just sort of sit around and talk with people individually afterwards to see if we can answer any questions or get more feedback.
Okay. Okay. Well, let me say that it is 12:07 p.m. and that will conclude the hearing. Thank you very much. And then we'll be here to answer any additional questions.
Thank you.
I have a general question about the testimony that was taken today and that you recorded. Is anything that's going to be off topic just sort of be thrown away, or are actually people going to pay attention to the side comments as well? You know what I mean?
Well, certainly nothing will be thrown away. But the only parts that can be considered are the ones that are specifically relevant to the rules. Now, what I'm noticing in some of the comments, and I know it's hard to keep straight.
It's on, do you want to?
So we're finished the official hearing, so this is just, we're just discussing now. Is that some of the issues are really about the law, okay? And we're in the Department of Health and we have to follow the law that the legislators make. So some of the last comments I just heard about, we need to have, I guess Mike was making, we need to be able to get clones and seedlings. You were just talking about the using square footage rather than plants. The law is really specific. Oh, and do we need to have annual recertifications by physicians? Those are things that are in the law. So when we make up rules, we cannot do anything that's not within the context of the law. So if there's things that really need to be changed that are beyond the rules, I mean, that's fair enough, but what it needs to be done is you really need to get that through the lawmaking process. And one issue that I've heard so much today is about accessibility and the number of plants, and that lady from Kona that came over, not everybody can grow, not everybody can find a caregiver. People, you get your plants ripped off, the bugs eat your plants. Those are issues that are really are part of what's going on in the discussions about dispensaries, and it's something that we hear about everywhere. So as I said earlier, there are bills there's a really active discussion about that right now. That is the place to focus your energy around those topics.
And if those pass, then you'll be back for more of this then too, right? You have to come back for more public testimony?
Way more. So dispensaries are a far, far bigger topic. Believe me, dispensaries are 10 times as big an issue as the registry. This registry is basically about, signing, people getting signed up and getting their cards and a few other things. A dispensary has got about who can sell, what kind of security do they have to have. It's about money, it's about big money.
So without changing the law and with complying for the law, in the definitions section of the administrative rules, is it not possible to define a plant as something that has an independent root structure, a stem, and at least 10 leaves?
I believe it is not, because I believe that's already defined in statute, but I can look into that and find out more.
I don't think it is. And
I've heard it come up a lot before in the legislature, but because people are arguing, well, our stem, what about weight? So our stems and roots, is that part of what's usable? So I know that it's coming up there, so,
Well, usable marijuana is defined to include
Right.
things that really would not be usable
Right.
marijuana.
Right, not usable, right.
But I do not believe anywhere in section 329 or elsewhere is a plant defined. And I think we can all agree that plants have roots, a thorough root structure, and some minimum number of leaves. I think it's at least 10 or 20. But if you define them that way, then people would be able to replace their existing plants without having to deal with the black market every time, assuming.
so how would that work? So you'd have 7 plants as defined, and if they're smaller than that, like if they're seedlings or clones, then they wouldn't be included in that total of 7? Is that what you're thinking?
That's what I'm thinking.
Well, because the seedling is not a usable marijuana anyway, right? So
Yeah,
you're thinking it would fall outside of whatever definitions are there.
I think it could, the definition could be written so that it would fall outside, and I think it would be very good for that to happen. Because then a patient, I mean, initially, until the health department supplies us with seeds, we're gonna have to always go find seeds somewhere in the black market. But we wouldn't have to keep doing it.
And that, I mean, that's a recognized point. I mean, how do people get seeds? If you're, it's legal to grow, but you can't, where do you start them from? So that issue has come up before too. I'm sorry, what was your name?
Rex.
Rex. The issue about primary care provider, and a number of people have brought that up. The introduction of the concept of primary care provider was in the bill in 2013. And there is no definition of primary care provider. So,
May I interject, there is for insurance.
there is for
cases, though.
insurance
And
purposes.
sometimes he would be the primary.
You can be, but this is not for insurance purposes. This is for the purposes of certifying patients for the medical use of marijuana.
Exactly, but once he becomes a primary, doesn't that limit another physician from becoming the primary?
Well, it depends on the system you're working in, but you can always do a consultation request, and that doctor can be a concurrent treating doctor who specializes in different areas, like a surgeon, or someone who prescribes marijuana, or someone who does other pain management, ESIs, epidural injections, things like that.
The way that it's worded, and I would encourage you to look at it really carefully, because it's been written in a way very consciously to try and not limit access, okay? And it's written as the primary care provider who is certifying the patient for the medical use of marijuana for that condition.
So that's a problem, because there's no medical doctor in the world that is gonna do that. They don't want,
That's Dr. Berg though. Dr.
Right.
Berg.
they don't want DEA on their ass, they don't even wanna do Vicodin or codeine or
But
anything.
Rex, who were you referring to before? Because you're saying before you were making this referral and that was working, correct?
Well, there was people in town you could refer people to.
That were able to write the certification.
Yeah.
So there's still those people in town, correct?
Yeah, but they're not primary.
Right, so on so in my mind though, on the application, you specifically have to designate your primary care physician for the medical use of marijuana and write in that physician's name. Because we recognize that who you might normally see as your primary care physician for insurance purposes might not match who your primary care physician is for the use of medical marijuana. And so you're specifying that on the application and saying, yes, Dr. Berger, whoever, is my primary care physician for the medical use of marijuana. And so in my mind, or at least in the way we think we framed it, it should take care of that conflicting definitions of medical, because you can't file for insurance, right, for medical use of marijuana.
Right.
It doesn't come under that, right, not yet.
Right.
But it doesn't come there. So in theory, that would still be the same practice. You just,
But when people bring this up, I suggest to them that they call their doctor and tell them they'd like to get a prescription for medical marijuana, and see how long it takes to get the hang of it. I promise you, if everybody in this room calls their primary
I have a
health
doctor, Dr. Ledford, but unfortunately he's leaving Hawaii because of the administrative problems he has dealing just with being a practicing physician in Hawaii, and the fact that he had to take a big cut in pay to come here just to be with his family.
There's one doctor in Hilo that does pain management, Dr. Bay, God bless him. If it wasn't for him, there wouldn't be anybody doing pain management.
I actually used to work
I know that's a
for
problem.
2 of them. There are several pain management doctors in Hilo, but I can't see them touching this with a 40-foot pole.
You know,
Dr. Smigel is not gonna put herself out there for this, and neither is Dr. Rulin. It's always going to be a specialist. It's never going to be a classic primary care physician relationship.
Well, I hope someday we can change that.
I do too,
Yeah.
but I've been working on this too since 1988, and it has taken that long to get this far.
No,
That's the issue.
What Scotty's saying is really true. That's one of the objectives that we have is making more doctors familiar with the program, understanding how it works, even creating CMEs, continuing medical credits for physicians to learn about it. And we're going to try and do that by working with the community to do that, because having just a very narrow group of physicians puts a lot of pressure on those physicians and limits access to doctors. Mike?
Okay, I got a big question. Back in January 2nd, I sent you guys a letter saying we've opened a collective. One of the laws changed. They got rid of, you can only distribute, transport, and acquire between patient and caregiver, and they put medical use. Because of this change, we've opened a collective. We're now transferring medicine among medical patients. If they got excess medicine, they bring it to the collective. We transfer it to somebody else for just compensation. I sent you guys an email. I think she emailed me back and said, hey, we didn't say all the laws were on the website. But since then, I've been ignored. I've sent you guys a notarized letter saying, hey, we've got thousands of cannabis patients on the Big Island and the rest of the state waiting for the health department to tell us, are we doing this legally?
Health department can't advise you.
It's the law. What we're asking is, are we following the law?
Correct.
At some point, the health department's gonna have to answer us. You tell us about the other laws. Hey, there's been a change in maturity. There's been a change in how much you can have. Well, they also changed this. Why aren't you guys commenting on this? And when are you going to? When are you gonna let us know, and all the people in the collective, if we're breaking the law or not? I'm in charge of this collective.
Yeah.
My ass is on the line. I'm basically asking you, hey, am I going to jail here? I think I found a way for medical patients to legally transfer medicine to each other. And you guys aren't going, hey, Mike, you're right. Hey, Mike, you're wrong. You're saying, hey, Mike, we didn't bring that up. We didn't bring up all the laws. My point is this. At some point, you guys are going to have to weigh in on this. You're the guys running it. So run this up to the Attorney General, whoever you got to run it to, and let's find out, because as you can tell, I'm ready to fight. I'm ready to take you guys on your court. I'll kick your ass, and you're going to get in front of legal access to safe medicine. If you guys want to get in front of that, please do so. If you want to get behind it, please do so. But as the health department, you don't get to just stand there and go, no comment. The NED could stand there and stand silent on stuff. You guys are the health department. We're not going to allow you guys to stand silent. This is an important issue. When are you going to let us know? I'm asking you a question. I've emailed you guys. I've sent you notarized letters. I brought one down here to the health department upstairs. You know what they told me? Oh man, you got to talk to the state. They wouldn't even accept the letter. This doesn't make sense, guys. You're standing in front of the only legal way for patients to get safe access. If you're going to get in front of it, please do so, because I will mow you down. If you're not going to get in front of it, get behind it and let everybody know they can start transferring medicine legally. This gives us a safe access to safe medicine until you guys finally get your stuff together and can, because I can tell you what Leslie Ann Kobayashi, my favorite judge, she's a federal judge over in Oahu. What she ruled on an insurance case was medical marijuana is illegal in the state of Hawaii because there's no way to obtain it. Until you guys give us a way to obtain cannabis legally, it's illegal. Period.
It's a legislation.
And what I'm telling you guys is I've come up with a way of letting you guys do that, the collective, now medical, and the law appoints it. And if it doesn't, please explain why, where they X'd out no longer patient and caregiver and put in medical use, how that doesn't mean we can transfer among each other. So my point is, if you're going to say no, have a reason. And if you're going to say yes, please do so promptly. Say no, I sue you. Say yes, we'll applaud you. It's that simple. Can you answer the question today, or do you need more time? It's already been 3 weeks. I've already waited 3 weeks. That's the question, guys, that's the big question. Does anybody here have the power to answer it?
Well, given the choice of the applause, or what was it? Or we're getting mowed down. Mike, we cannot answer you today. And I wish.
Why?
And I'm not sure we will be able to answer you because we don't have legal, we're not the law interpreters. But I would suggest if you're doing something that is at all questionable, that's involving the law, that you get somebody on your side from legal aid or somebody like that to give you legal advice.
Who would you suggest?
Well, why don't you bring an assistant AG with you when you come?
Well, we have talked to the AG, and it doesn't appear that there's anything in the law that would permit it, but until there's like a really official kind of...
Well, then what does it mean? What is your interpretation? I've noticed you guys brought up the other ones, the other changes, but you don't bring this up. Is there a reason why you don't bring up this change?
It's HRS 329121.
It doesn't, yeah, I mean, Mike brought it to our attention what it is. It does not appear that there's anything significant intended by that change.
What did it mean then?
It didn't appear to mean anything, and...
They changed the law and it doesn't mean anything? That's your answer? There's been a change in the law, but it really doesn't mean anything.
So, what...
I'm just trying to get the health department's rational point of view. No, a law, every change in a law means something. As you guys noticed, when you took out, if there's a problem with the application,
yeah, no, your point.
You guys took that out and went, hey, if we want to come check anytime we want. Hey, that's a huge change, my friends.
Right.
One is before application, one's anytime they want. My point is, this has been a huge change. At least comment on it, please.
Well, so what the AG did is she went back and looked at all the discussion that was related to any changes in the law, and at no time did that come up in the discussion.
No time did what come up? The change?
On the change that you've mentioned.
But you admit it's there, right?
We can see it.
We saw what you showed us.
You've seen it,
But we
right?
don't know why it's there.
It's there, I'll tell you why. God put it there. It doesn't matter who put it there. It's in the law, right?
It's in the law.
It's in the law.
It's in
You
the
will
law.
admit that, right? It's in the law.
I can see it.
Wants to know why.
I don't know why.
And you guys won't even comment on the change. You don't know how it got there.
You know,
It's like Mitch.
you just got the comment.
Can you give a time
And
limit?
my opinion on whether.
I've already given 3
This
weeks.
personal guy?
Oh,
right
okay,
there?
well, hey guys, what can we do to get to the bottom of this? Because like I say, 13,000 patients across the state, hundreds already in the collective. It's the only safe legal way. What am I trying to do? I'm just trying to give people safe access to safe medicine. As a collective, you know, we've got a machine that can test for pesticides, molds, THC, CBD, all these things. We got ovens, purge ovens for making oils. Hey guys, we're the only safe legal way to do it, and you're telling us no. No, the AG doesn't think there is a way, even though 15 years ago you gave us the right to do it. They changed the law last year, and you're trying to say that this change means nothing, you still can't do it? It's still illegal in the state? Come on, guys, that's ridiculous.
These are doctors, not lawyers.
My point is, you're in charge. Take a chance. Take a stance.
Oh, yeah.
Stand up to the AG. Stand up to the world. Guys, you gotta give us a way of doing this. If this ain't the way, what is the way? Don't say only the legislators can do it.
I want to interject. This is really an incredibly timely and important issue. People are really seeing these videos, Rick Simpson oil, where people have been cured of cancer, and then they're getting a diagnosis of something that suggests they have less than a year to live. They call us, and here we are.
Pancreatic cancer, dead in 10 days. Can I give them medicine? No. Why? Why is that, guys? Because of the Attorney General's interpretation of the law? Come on, it says right in the law. They got rid of patient and caregiver. It said medical use, distribution, transportation, and possession. You telling me that means nothing? That's the health department stance?
No.
Seriously?
It's not the health department's stance.
Isn't that what you just said? The Attorney General said, we don't think it makes any difference.
Well, that's because, Mike, what we're really trying to do is, if there's a way to get through that to get good access. We want to find out if that was the intent of the change in the law.
The intent of the law, Act 228, it says right in it, look it up, 15 years ago, compassionate, uninterrupted use. This falls right in with that, guys. Somebody finally fixed it. It was a small paragraph. You don't know who put it in. I wish we could find out because I want to kiss them. But my point is, hey, I'm ready to go to trial on this. And at least, you guys got to at least weigh in and say, Mike, don't do it. If you're not even going to tell me not to do it, tell me not to do it so I can sue you.
Well, that's fine, why would I do that then, right?
You know, our advice just isn't worth that much on this because it's...
Advice? You're running the program, my friend.
We're not lawyers.
Can they file a petition for declaratory?
Well, can I make a suggestion? Can I make a suggestion? You're talking about law enforcement, police coming after you?
I'm saying that we're a collective. We've noticed a change in the law. We've opened this collective, and the change in the law says patients can now transfer medicine to each other. We're doing it.
Okay.
And I'm asking the health department to weigh in on that. I've called you guys, I've emailed you, I sent you a notarized letter. What more can I do?
Okay, well, I'm trying to answer that question. Give me a second. Okay, I'm sitting here as a hearings officer, just the moderator in this, but I actually do happen to be a lawyer. Okay? If you're asking that you want to avoid arrest for something.
I'm asking the health department to approve us.
Oh, okay.
Or not.
Okay, if you're saying we are
Yes
doing,
or no?
we're saying if we do this, would we be arrested for it? That's a question you can ask the Attorney General's office
I'm
for an
asking
opinion
the
on.
health department.
Whoa, because the health department can't tell police not to do something.
No, they can't.
But the
They can
attorney-
say
but
it's
the
legal,
attorney- but
or they
the-
can say it's not. Well, tell me this, aren't
But
you
the
guys
attorney-
to call
but
NED if you're suspicious? Doesn't it say, hey, if we think there's a problem, we're gonna send NED to do a compliance check? Or consequently, you guys can say, hey, NED, no problem, stand down. Am I wrong here? You guys either tell NED to go in, or you tell them, hey, there's no problem. All I'm asking you is this a problem or isn't it? It's that simple.
If you want something binding upon law enforcement, okay, you go to the Attorney General's office and ask them for an opinion. The Attorney General's office can give an opinion through the statewide director of law enforcement with the state imprimatur, which overrides the county of Hawaii, county of Hawaii, whatever. If you can get an Attorney General's opinion saying that what you're doing is okay, then you're pretty much in good shape.
Okay, but
Because the
until
attorney,
then-
because if the criminal division of the Attorney General's office disagrees with what the Department of Health says, they're gonna go ahead and prosecute anyway.
My point is, you guys are in charge. Aren't you in charge of the medical cannabis program?
I'm in charge of registering patients, but we're not in charge of making legal interpretations. I think his
Okay,
advice
well,
is very good, though.
You brought up the other
You might
laws,
wanna
why
try
don't you
that.
bring up this one? I'm just wondering, you don't have it on your website. When are you gonna weigh in on this law? When are you gonna bring it up? And what are you gonna tell people about this law? I'm asking you, straight up, what are you guys gonna tell
Can I
people about
offer
this
something
new law
that might
change?
ameliorate this? Earlier you said there's nothing you can do. Have you ever heard of the blue collar flu? You know what that is?
No.
Well, you never heard of the blue collar flu?
No.
This is where police officers don't go to work because somebody screwed up administratively. Because they want to make a stand and demonstrate to the authorities that you're doing something unjust. Now, oftentimes it's for their own benefit because they still like to beat up black people, but that's another story. In your case, you could make an in-house decision and take the onus of the Attorney General coming down on his house, and you take it and say, look, we're operating in lieu of this, and we see the tone and climate of what this means, and as physicians,
And intended
do no harm.
legislative intent.
By
That's what
not
the law
acting in
meant
this way,
15 years
you're
ago,
doing
guys.
harm. I'm just suggesting that you, now, trying to imagine your department's going to have 30, 40, 50, 100, 200 people that are going to take a stand and pass these things through and approve these things. I think it would be a wise thing to do, because it would show leadership, it would show you're willing to take the risk, it would show that you support us.
And your stance shows the truth. Who wrote the administrative rules? The Attorney General. You can tell it was wrote by a prosecutor. I mean, just look at it. You
And
can
look
tell
what
it was wrote
happened
by
when
a
we put our faith in
prosecutor.
a prosecutor here in
Come on,
Hawaii with
guys.
Peaceful Skies. This is like almost a Cheech and Chong movie. These guys got Peaceful Sky Alliance, And if you read the rule, it says it's up to the prosecutor. So this whole thing with thousands of people, 62% of the people voted, not just all the weed users, people who wanted their children not to be criminals, who wanted their tutu not to be criminals. They supported peaceful skies. The law comes in and one person stops it. One person. So this is not moral or ethical. It is legal. And this is one thing I had to learn the hard way, that laws are only legal. They are not ethical or moral. And we're talking about ethical and moral questions which you could take the leadership on and get a little blue-collar feather and either don't let paperwork go through or make paperwork go through that they have to deal with.
Advocate for the people you represent.
Exactly.
Thank you. And how can you change, a change in the law means nothing?
So forgive me. But I thought it would be
Did
a
the
way
other
to-
changes mean nothing? Does that really mean we still only get 3 ounces even though it says 4? Do we really only get to have 3 mature ones even though it says we can have 7? Why does this change in law mean nothing? Please explain that to me.
I think
Mediator.
you should get an attorney and talk to your attorney.
Well, I ain't got, you know, I'm gonna have to get one after they arrest me apparently, but I don't have any money, so I'm gonna have to go pro
Well, there
se.
must be attorneys interested in that.
Pro bono?
Yeah.
We talked to one.
Well, and perhaps ACLU would be somebody, I mean, if you believe and you're obviously acting on this, I would send.
Hey, we're already doing it. I totally believe in it. I'm
No,
willing
I
to
hear you.
litigate you guys. I was just hoping you would say, no, you can't do it, so I could sue the health department. It looks like I'm gonna sue you guys anyway, because that was my next question is, are you gonna change any of these administrative rules? Or are you just gonna try to promulgate them as they are?
These here, you mean?
These ones here that we're talking about, are you gonna listen to us and make any changes? I'm asking you guys. Will there be any changes made from these meetings? Or is this just gonna be promulgated in front of the legislation as it is? Is this your final draft? I guess would be the better question. Are you guys,
This is still a draft.
Oh, okay, so you might make some changes.
Might make some changes.
But
I would rather hear we're going to make changes, because definitely with what we
Well,
heard today.
you know, what we'll do is we'll have 3 more hearings.
All right.
And then what we do is gonna look down and see what people have said and what it is in common. You know, and one of the things I'm just hearing today is, you know, something that is a fear that people are gonna come to your house 24/7 in the middle of the night and stuff like that. I mean, if there's anything that suggests that is possible,
it's in black and white, when you're changing, it says anytime, day or night.
I mean, that's, I would say that is 1000% clearly not the intention. So if there's something that makes people feel that they're threatened in any kind of way, that's not appropriate.
You ought to go to the legislature, that's where this has to start. Because if they change the law, if they pass the law, then he has to come back here and do this again. And then he has to answer you, yes or no.
You've already written it. You've
But
already
I'm just referring to the question of, is there a need for changes and are we listening? So what we've done is we have a recording of what the statements are. We're gonna actually transcribe that, so we're gonna figure out what were all the issues that were raised. We've been taking notes, we're gonna do that in 4 places. Then we're gonna sit down and look at what are the issues, what's clear, what's not clear, what needs to be changed or not changed. So that's the process. And the written comment.
Yeah.
So the reason you've mentioned the other changes, the one on 3 to 7, 3 to 4.
Because they're ones because we're aware of those.
You're aware of those, but
and
this
it's
one
that
here,
kind of-
you don't really know.
Never came up, it never even came up until you brought it up.
Interesting,
Wow.
isn't that amazing? Somebody snuck that by Josh Green. They snuck it in there and they kicked his ass. And you know what? It's over,
Wait,
guys.
wait.
We got it. It's the law.
If it's the law, then you're good to go.
Well, that's what I wanted to hear. That's all I wanted to hear. Thank you. You heard him. We're good to go.
Mike, before you go, from our understanding, and I don't know if Scotty's still here, it's about the 2-month delays.
Yes.
Yes,
So
2 months delayed.
we are
That's
not-
illegal, guys, in your own administrative rules, right? People who receive.
We're not aware at this point of any 2-month delays that are going on. Now, we know from before there were 2-month delays, but we know exactly when an application comes in.
This is
and
what
when it goes
doctors
out.
have been telling.
So is this from before?
No, yes, and this is your average.
Well, no, we only started 3 weeks ago.
Okay, well, your average is
Well,
2 months. I've had them take as long as 11 months.
Mike,
I
we
didn't get a
started-
card until there was 1 month left on it.
We want
That was
to do it right,
public
okay? So
safety,
we started on January the 1st, okay? There's no way we can be 2 months behind in something that's not 3 weeks back.
Appreciate you being here. I'm not mad at you, my friend. One file humor.
No, I
I'm
know.
really pointing out, I'm trying to get safe access to over
But we
15,000
want to make
people.
sure that.
Help me out, will you?
We
Come
want to
on,
make sure that
guys.
people are not delayed in getting their cards. So if you are having a problem getting your cards, which, not 2 months and 3 weeks, but we are keeping track, we know when
What
they
about
come
the
in.
receipt? Can you
we-
issue a receipt?
We won't need to.
I already went out there and talked to Scotty already, and she explained it to me like this, when, like, she gets my application now, which is a couple, 3 weeks ago, it will be dated for the end of January. So this time doesn't even count on my year anyway.
Well, that's more helpful.
Technically, that is the other part.
At least you're not getting ripped off for the time.
Right.
He hasn't got his card
My
yet.
point is-
My
that part
point
we have
is,
to
what
take
if
care
you
of.
got pancreatic cancer and you don't have 2 months?
There is no 2-month delay. You need to stop saying that because I am.
This is what doctors do.
I want you to stop saying it.
It came from Dr. Bird. Can I say this? If there's a delay, it says in the law, you're supposed to
Yes.
issue a receipt.
I will get you your
Will you
card
start
before
issuing
I ever
receipts?
need to send you a receipt.
Okay, well,
Okay.
I'll take that.
But what happened-
Not mad at you, sweetheart.
I'm just saying.
I'm
don't
not
be
mad at
bad
you.
mouthing me and
I ain't trying to badmouth anyone.
I've been working
I'm
on
just wondering.
weekends for you
Well, I'm
guys.
just saying, your 5
I
A's,
come in on my
accessibility,
holidays for you guys.
accessibility, affordability, all these things,
I
but
can-
yet you guys won't speak up on the biggest change in the law that makes it legal?
I cannot give you a legal opinion, I'm sorry.
Legal, I just want the health
I
department
cannot give
opinion.
you a legal opinion. I cannot.
They can't.
I cannot, I just
AG
cannot.
can though.
I cannot.
I have one
Go.
comment to make.
I cannot.
Who are the legislators and governors and such playing golf with? Are we seeing? No, I'm
me.
serious. Exactly. Drug company, are we finding Glaxo and Squibb and all these people coming
Well,
over here
it's just
saying,
like I always
keep this
thought.
medical thing down, we want to
Me
make
against the
money?
Attorney
We
General.
need to change the scheduling, you guys already know what needs to change. You guys need to testify on the bills.
No, you know what?
We wrote our bills. You got it.
I'd love to ask you.
I want to say, I
Now I know
emailed
who
you,
to
I
sue, I
remember
guess.
your email, and it came before his, because you used your email address.
Yeah, thank you for your comments. Yeah. So, you know, if you're at some of yours that are
Which
laws
one?
and
You
some
sent
are
me and
roads
asked if
and.
we were gonna have a representative.
But the director isn't doing all this stuff.
Yeah.
The director is anybody, the director or anybody appointed by the director.